should have received a handout and an index card. So if the index card, if you wouldn't mind putting just your name on it, we're going to do a raffle at the end of, I pull a name for a Starbucks gift card. So your positive reinforcement for sitting through the training. There. So if you're here for suspensions, expulsions, arrest, and Baker Act, oh no, you're in the right place. Let's see if technology will work with me. So I'm Ann Siegel. I'm the Director of Advocacy, Education, and Outreach with Disability Rights Florida. Disability Rights Florida is your state's protection and advocacy agency. Every state is mandated to have a P&A. We provide free, confidential legal and advocacy services, and we are statewide. And our mission is to protect and advance the rights of Floridians with disabilities through advocacy and education. So we're going to cover suspensions, expulsions, arrests, and Baker Act, but I'd like this to be very interactive because I'm here for you and what questions you all may have, so you don't have to hold questions till the end of the session. We have about 4 scenarios that I'm going to put up, and I kind of want your interaction on what you see are the problems or what you see should be done to resolve the issues. And I believe we have a handy dandy mic so that your questions will be heard, that we can kind of, I guess, if you wouldn't mind if they need my assistant, also my daughter. It's great. Have kids, will work for free. So, all right, let's get started. We're going to start off with suspension, which I guess you can tell by my little cartoon there that I think is a meaningless task. And we're going to our first scenario. So Timothy's a 3rd grader. He had an outburst at school. He bit and kicked the school principal. The district suspended and unilaterally removed Timothy to an interim alternative education setting after the student allegedly violated the student code of conduct by physically striking others, including the principal, while acting out. The district notified the parent that special circumstances justified removing the student to an interim alternative education setting. And specifically, the district contended that because the student inflicted serious bodily injury upon the principal during the altercation, it could remove the student without conducting a manifestation determination review, and the parents appealed the district decision. And an important factor here is Timothy is a student with a disability who's already been identified as requiring special instruction, and there are some procedural safeguards for students with disabilities when they violate the code of conduct. So would anyone like to point out any violations they see or what they thought should have happened?
Notify the parents before they remove them?
If the child has an IEP, doesn't that protect the child?
Yes. And then if you wouldn't mind, if we could get her comment on. You're going to get your steps in today.
Notify the parent before they make that move.
Okay. Anyone else? All right.
Conduct a manifestation
Determination. review.
determination.
Yes. All good answers. So what happened was the hearing officer in this case said you just can't, special circumstances can justify removing the student to an interim alternative education setting. What I said was he had committed serious bodily injury according to the district. But the problem was they didn't They didn't conduct the manifestation determination review because they went under the zero tolerance issue of he committed serious bodily injury. So in that case, they kind of just passed go, didn't collect their $200, and ended up removing the student, which was a violation. They should have conducted an MDR. It didn't rise to the level of serious bodily injury. And only the individual education plan, we've got lots of acronyms, only the individual education plan team, which is also known as IEP, can place a student with a disability. So even if you've violated a code of conduct issue and it's not a manifestation, still placement is determined by the IEP team, not the district, not the principal, not the superintendent, not the school board. So, IDEA states that behavior intervention plans must focus on positive behavior interventions. Restraint and seclusion is not a positive behavior intervention, and I can tell you that in a lot of the districts that we advocate for students, we see them putting it on the individual education plan or the behavior intervention plan. It's not appropriate. Restraint and seclusion is a crisis intervention, and it's by no means positive. So when the behavior impedes a student's ability to gain educational benefit and making meaningful progress, then the school should conduct a functional behavior assessment, also known as an FBA. So when you're disciplining a student with a disability, you may hear some people refer to it as 10 FAPE-free days, FAPE standing for free and appropriate public education, because the way the law reads is a student with a disability can be suspended up to 10 days without it possibly constituting a change of placement. It is on the 11th day that it could be considered a change of placement, and a manifestation determination review must take place. And we have a lot of misinformation out there. Some people think it's 10 days consecutively. It is 10 days cumulatively. So we've known, the kid's been suspended 2 days here and 3 days there, and, or happy home time with the parent or legal guardian, which is, we're not suspending Johnny, but we could, so you just need to come pick him up. That's a suspension. So if any time any of the children that you represent are being told that they get to go home and you can pick them up, that's constructively a suspension, and you need to get that documented, or else it sort of looks like you all are picking up the student and taking them home half day. And it doesn't count towards the cumulative 10 FAPE-free days. So on the 11th day, you need to hold a manifestation determination review, and there are 2 important questions when we're doing a manifestation determination review, and these are the only 2 that are mandated under the law, although many of the districts that I advocate in, they have a plethora of questions they will ask. I had one recently that had over 100 documents that they wanted to review and go over and determine, and it took an awful lot of time, but at the end of the day, I kept telling them and reminding them that there are really only 2 questions, and those are, if the conduct in question was caused by or had a direct and substantial relationship to the student's disability, or if the conduct in question is a direct result of the LEA, which is the local education agency, which is really the school district there, failure to implement the IEP. And oftentimes, you're going to get bogged down in people talking about whether it is the student's eligibility, that would a student with that eligibility commit this kind of offense? And that, again, is not how it works. It's not, I'm a student with a learning disability, therefore I couldn't possibly have behaviors. I'm a student with a learning disability who experiences a lot of frustration, and I don't know an effective way to communicate that. So in order to avoid the assignments that I find too frustrating, I act out. So it is part of my disability. But oftentimes I've sat in meetings and they've said, Johnny has a specific learning disability that doesn't have a behavioral component, therefore it's not a manifestation of his disability, and that's incorrect. We don't go by eligibility or label, we go by how that student's disability impacts that student's behavior. And I have to say, I've been advocating for kids with disabilities for roughly 22 years, and every time I think I've heard it all, I'm not surprised. There is somebody who'll come up and shock me. And of course, we don't hear the good cases because nobody calls us and says, we're having a great IEP, please come and have tea and cookies with us. We get called because the student is being suspended multiple times, they're, having behavioral referrals and all kinds of issues with the student receiving free and appropriate public education. So, if it is a manifestation of that student's disability, they cannot be suspended. That would be punishment for the student for circumstances beyond their control. So if those two questions that were asked, if either are a yes, then the student doesn't get suspended, the student doesn't change placement, unless, of course, the legal guardian and the school agree. Because sometimes, and I've had cases where there was this parent had been asking for their child to be moved to a more therapeutic educational setting. And the school district kept saying, he doesn't need that placement, he doesn't need that placement. And yet he was getting a lot of behavioral referrals and a lot of suspensions, and then ultimately being bullied. And the student went to the teacher and asked the teacher to protect, and the teacher said, you need to man up. So the next day, my client, who had an intellectual disability and some mental health issues, came into school with a rubber band gun and scissors and decided to man up. Thankfully, he didn't take the scissors or the gun out, but they did find those in his possession because other students told on him, and they decided that they were going to move to suspend and expel. And when we went through the manifestation determination, it was determined that yes, it was a manifestation of the student's disability, and we agreed to a more therapeutic placement, which ironically the parent had been asking for several years before we got involved. So when I talked about the interim educational setting and the serious bodily injury, that falls under the special circumstances, which you all might know as the zero tolerance issues that happen. And those are when a student carries or possesses a weapon at school, knowingly possesses or uses illegal drugs or sells at school or at a school function, or has inflicted the serious bodily injury, which in that case, that's what the principal had alleged, since the principal had been kicked and hit. But serious bodily injury is actually defined by bodily injury which involves A, substantial risk of death, B, extreme physical pain, C, protracted and obvious disfigurement, or D, protracted loss or impairment of a function of a bodily member, organ, or mental faculty. So while I'm not condoning hitting and kicking your principal or any of the school staff, I am telling you that does not rise to the level of serious bodily injury. And we get a lot of cases where that's misunderstood. And we actually had one where the student grabbed I believe it was the speech language pathologist, by the shirt, and was holding the teacher's shirt. And they claimed serious bodily injury, and of course our response back was, while we know cotton breathes, it was not at any risk of danger of death at that point. So it didn't fall under serious bodily injury. And oftentimes then we're accused of, wanting our clients to run amok and to batter the staff. And that's not what we're saying. What we're saying is, it needs to rise to the level, and that we need to follow the procedural safeguards for students. So we're moving on to expulsion and our second scenario. So Johnny's a second grade student with ADHD and other disorders. He has multiple mental health diagnoses. He has a history of violent and eloping behavior. So Johnny likes to, when the going gets tough, he will take off out of the classroom. Johnny's in a classroom for students with therapeutic needs. So he's already been identified as a student with a disability and that he has emotional behavioral disorder. And he's in a therapeutic placement to meet those needs. The school has attempted to revise his behavior intervention plan and his individual education plan. Johnny's behaviors haven't gotten better, they've gotten worse. So Johnny stabbed a classmate in the head with a pencil and wrapped his headphones around his neck when his teacher stopped him from exiting the classroom through the second-story window. The principal determined Johnny was a threat to himself and others and expelled Johnny from school, all on his own. So, what do you see wrong in that scenario?
I see the word attempted to revise his IEP and BIP.
Attempted.
There's also no manifestation, meaning
Yep, no manifestation, a feeble attempt at revising the behavior intervention plan. Anyone else? Okay, while he had committed, move on to the answer. So the district was found to have denied the student a free and appropriate public education by failing to provide the student with educational services, and he was expelled 3 times due to his violent behavior. So they failed to look at the behavior intervention plan, conduct a manifestation determination, and while the student had violent behaviors, it still did not absolve the district from providing educational services. So you can't just say, you're violent, you need to go home, and you're your parents' problem to educate. While a student with a disability can technically be expelled from school or suspended from school, they still must be provided a free and appropriate public education. And that free and appropriate public education is not a home packet. It's not, okay, we'll give you 2 hours of home instruction a week in the library. It has to be reasonably calculated to confer educational benefit for that student. So, whoops, back it up. So they need to conduct a functional behavior assessment. And an FBA needs to be data-based. They need to review records. Oftentimes we'll come in and we'll get the student's records and we'll look back and find a history of the same behavior repeating itself for years and years and years, and a history of suspensions or, happy home time with the parent, and nobody's ever addressed it. So we look at the records, we look at referrals, we look at discipline reports, and observations are also very important. So all behavior has a function. Often it can be task avoidance, frustration, communication, especially with our students who are nonverbal. And when it does, and we look for the pattern when it occurs. So I had a student who was in middle school who was not successful in reading. And this student acted out every day in the afternoon and got lots and lots of referrals from this particular teacher. And it wasn't that this teacher was a mean, horrible person. It's just my client liked to act up in that classroom. And so we were meeting with the school and asking for a functional behavior assessment and a positive behavior intervention plan. When I looked at the records and I found the pattern was the behaviors were always in this class. This class was towards the end of the day, and it was reading. And reading was a weakness for my client. And his meds had started to wane by that part of the day. So it was like right after lunch and hanging out and being all overstimmed, and now he's supposed to come into the classroom and conform and do his least favorite activity. So when we discovered, which I kind of couldn't believe no one had put two and two together, but they hadn't, we looked at it, we moved reading to an earlier time in his school schedule so that a non-preferred activity would be given to him when he was, functioning at his best. And there's always an antecedent to like what caused the behavior, and it concerns me greatly when I go to a school and I ask, well, what created this behavior? And they come back and they say something like, well, nothing, just out of the blue. Johnny decided to tear up the classroom, and that may be what it looks like. But if you don't go in and do the observations and the data collection, you're not going to know. And obviously, I'm not a certified behavior analyst. I'm just a lawyer who's been advocating for kids with behavioral challenges for a long time. But I've gone to a lot of trainings and I've spoken to a lot of behavioral experts, and this is the information that they've kind of imparted on me. So the components need to identify target behaviors. We need to address that, and it's the behaviors. Yes.
I'm sorry. I think you said you wanted us to interact. So,
Yes, absolutely.
So what I want to make sure I understand, I've got a 13-year-old who's not got any diagnosed learning disabilities or anything, but she's been suspended way more days than she's been in school. She's 13, and she's a sexual abuse victim. In my mind, she's disabled, behaviorally because of all the sexual abuse. And I'm trying to figure out how to advocate for her because the school district's response, they put her in the alternative learning center, and even they repeatedly just, suspend her for 10 days at a time. So I'm just wondering, is a functional behavioral analysis appropriate for a child who's not had an IEP and has never had a diagnosed disability?
It is, but I would also say that the school district has a child find obligation to evaluate that student, because you're talking about a student who's had significant trauma, and therefore there could be an emotional behavioral disability that would qualify that student for specially designed instruction in that area. So even a student who, because we hear this a lot, is able to maintain passing grades can still be a student with a disability, and it was the school district's responsibility to evaluate that student, identify that student, and provide that student appropriate services. And that student could be eligible for compensatory education because they've been denied a free and appropriate public education. What ends up happening is they just keep looking at the student as a student who acts out and not a student that they've not yet identified. And by the way, when you ask for an evaluation of the student, that now puts the student protected under the procedural safeguards of the Individuals with Disabilities Education Act, because that is a student considered a student not yet identified.
Okay, so the parent would write a letter asking for an assessment?
Absolutely. You always ask in writing, because if it's not in writing, it didn't exist.
Okay.
And in this case, I would ask for it to be expedited, since the pattern and practice and the concern that the student is losing, valuable education time.
Perfect, thank you.
So, and when you I'm sorry, was there?
And then ignore them when they say RTI.
Well, no, RTI can be done concurrently with the evaluation. RTI, which is response to intervention, cannot be used to delay an evaluation. And you'll hear a lot of that. Well, we must conduct 19 weeks of RTI, because I like the number 19, I just pulled that out. That's not how it works. What it is if you want to do response to intervention, because it's a component of the evaluation process, that's fine. But you're going to do my evaluation concurrently, and we're not going to wait for your response to intervention to finish. We need to make sure that that student is not delayed. And OSEP actually has a paper that they did out in 2011 that really put the school districts on notice that RTI is not used to delay the evaluation process.
Yeah, I was just gonna reiterate that, that's a big issue, I'm assistant general counsel in Broward and West Palm Beach, I'm not blaming any of those districts, but, I mean, in those areas. But a lot of people are really confused about the RTI, and that's really important to understand it, and I believe it's actually in Florida statute as well, that they can do it concurrently. And when a kid is having that kind of breakouts like you're talking about there, I think it is, you know, you have to have something that indicates that they might have a disability to make that RTI be concurrent, but that's pretty simple, because that's usually who the kids you're talking about. But that's used often, I mean, especially like when we have kids that are truant, they don't go to school, and they're bipolar, and they say, I can't do anything because they don't go to school. No, 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 they cannot do that to you.
Yes.
They need to do it concurrently.
Yeah, and those are triggers that should put the school on notice to do their child find responsibility. Kids who have poor attendance, kids who have lots of stomach aches or headaches or issues where they're constantly needing to go home, but yet they've received medical clearance. There is no underlying stomach, headache issue. It's just students just trying to escape from the, so they need to do that. And another big issue is behavior intervention plans that only address one behavior, because we had a district actually tell us we can only address one behavior. No, you need to address the behaviors that are impeding that student's progress. So you can do more than one, and sometimes there are an awful lot of them, but sometimes they're the same behavior, but with kind of different spins on it. Yes?
You named an agency. Oh, thank you. You named an agency that published a paper in 2011. I just don't know that acronym.
Oh, I said OSEP.
And who are they?
Office of Special Education Program.
Thank you.
Thank you. So, yes. If you Google it, it comes up. I mean, it's like on my computer. It's probably one of the most printed letters that I've had to send out. And it's 2011. We're in 2017. It's not something new. But RTI has one of those things that in theory was a good idea, but is in practice not really understood well. So they need to analyze the data and utilize that information, look for the student's strengths, reinforce, and come up with a hypothesis. Oftentimes I see these hypotheses that I think came from a drop-down menu, and I'm like, how does that relate to what my client's experiencing? And they're like, oh, don't worry about it, we have to put a hypothesis in there. No, just like if you're writing a research paper, that needs to be the hypothesis of this issue. So, now that we've done our wonderful FBA and it was conducted by somebody who was trained to understand behavior and not the media specialist at the school, no offense to media specialists, you do a great job, but you're not behavior experts. So now that the the CBA has done this, or the person specially trained in behavior has conducted it, it's time to write our positive behavior intervention plan. And so the target behavior is that one that interferes with the student's ability to progress in curriculum and to achieve the student's IEP goals. Once the target behavior is identified and the hypothesis is developed, a positive behavior intervention plan can be prepared to address the target behavior with strategies and interventions, and if necessary, our target behavior can be addressed using more informal approach. And best practices are to involve the student, parent, legal guardian, any private providers, especially oftentimes my clients have a behavior therapist that is providing services in the home or in the community, and the behaviors are pretty well controlled in the house. So I'm like, they've already got something that's working. Why don't we take that information and not reinvent the wheel and come up with a good positive behavior intervention plan for this student? So it kind of takes a village and get all the players in there and come up with a plan that's going to work for this student. So these are some of the components. Positive interventions, what's going to happen what are we going to do when this behavior, how will we identify what, and it's best to catch the student when they're actually modeling good behavior and reward them for acting appropriately so that they're not, the only attention they're getting is not when they're negative. It's not negative attention, because if kids will seek attention any way they can get it. So if I'm getting no attention except for every time I throw my shoe across the room, you are reinforcing me to throw my shoe across the room, because the rest of the time I might as well be, a empty chair. So catch the student when they're being good, reward them for that behavior. Provide replacement behaviors. I've often been told you want to have really good positive replacement behaviors. You don't want the child picking up a new bad habit. So come up with some really good replacement behaviors that the student's going to buy into. And train all the staff, all adults at that school district should know Johnny's, behavior intervention plan, know how to interact with him, monitor and provide the services with fidelity, and expect that oftentimes things get worse before they get better. Move on to arrests. Yes.
Sorry, one question before you move on.
Mhm.
As far as the manifestation meetings, who is required to give a notice of those meetings, and how much requirement is there for notification and/or trying to coordinate a meeting time?
Okay. The legal guardian needs to be noticed.
What about the guardian letter program if there's assigned?
That would be great, but I'm going to tell you, in most cases, there's no, quote, legal obligation to notify. But I've had lots of cases where the guardian ad litem has been very involved and has come out to the student's school, and I would say best practice that they should be identified. But I'm going to tell you, oftentimes what happens in practice, they send it to either the foster parent or the group home, and nobody ever attends.
That's what happened. They, as a colleague's case, they sent notices to group home only, didn't notify the case manager, did not notify the guardian letter program, and then reached their determination that it was not a manifestation, by the way. And then, of course, everyone raised hell and they backed off and had another meeting, fortunately, with the right people present, but that was a concern about
Yeah.
who had to properly notify.
And it's one of the things that I always, when we're on a case, we also, because they say they have no obligation to notify their attorney. We notified the parent if the parent didn't tell you, and the parent will be like, I got nothing. I have a cell phone that takes voicemails. I have email. I got nothing. And they're like, oh, we put it in Johnny's backpack. And it's like, really? The backpack where all things go to die? So, yeah, notification's a big issue, and like you said, we've had to make them do it all over again, and then oftentimes they don't have the right people at the behavior intervention, at these manifestations. It really should be the IEP team members, because those are the people who understand Johnny's unique needs and know what specially designed instruction, related services he's supposed to be getting, and I'll show up sometimes and it's the principal, or my least favorite attendee, the school resource officer. So. No offense to law enforcement, but they really are not educational staff.
Say very quickly, BIP and IEP, is there any relationship between the two?
They actually they can be referenced. So if you have a student who has behavioral challenges, there should be goals on the IEP.
So
for
that they
student.
automatically would have an IEP. If they have a BIP, they would have an IEP because of their behavior?
In most cases, yes, but students can have an FBA and a BIP at a school and not be identified as a student with a disability. You also have students who are considered students with disabilities under Section 504 of the Rehabilitation Act. So they may have a BIP and an FBA, but no IEP, because all they need are accommodations and potentially related services, and they don't require that specially designed instruction to get that individual education plan. And remember, specially designed instruction is just not reading, writing, and arithmetic. It can be communication, it can be independent functioning, it can be social emotional, and that's where a lot of the clients that I represent fall under, because academically, they're making passing grades. And that's not the indicator solely of being a student with a disability.
Thank you.
Okay, so unfortunately, we see a lot of arrests in school, and I can just say that I'm grateful that I'm as old as I am, because if I were going to school now, I probably would have been expelled or arrested. So, lucky for me, yeah, I've always been very outspoken, so I would be one of those students who would be considered oppositional or belligerent, non-compliant, and I'd have lots of suspensions and potentially arrests, because disruption of a school function is viewed very loosely. Oftentimes, we've actually had a student who was arrested for getting up without permission and throwing a paper in the trash because they disrupted a school function. We were in class, and he got up and disrupted the class by throwing out trash. Or another student took their little skull cap and flinged it across, and it hit the teacher's leg, and so now it's battery on a school employee. So these are things that unfortunately I don't make up. They happen in life, and they're things that, like I said, back in the day when I went to school would have been, don't do that. Or the infamous, I'm going to call your mother, which quite honestly for me scares me more than if you had arrested me back then. So things are getting criminalized that really, unfortunately, and I don't think there's an understanding of how that affects the student down the line. And I've often heard people say, that doesn't matter, it's their juvenile record, it'll be sealed when they're an adult. And they just don't understand that's not how it works. Or the other, well, that'll get them services, because there's services in the juvenile justice that we can't access in the community. And again, that's incorrect information, but these are some of the myths that are out there that parents hear and school staff. So, our next scenario is Joe, a middle school student, eligible under other health impaired. He had numerous psychiatric hospitalizations. He was placed in a self-contained classroom in a center school, which is a school that are only for students with disabilities. He received counseling. He assaulted 4 district employees on the same day. The district sought to change his placement, but the parents would not agree, so the district reported the assault to the juvenile authorities, and the parents initiated a due process claim. Anyone want to try that one? Okay. Well, yes, the school can obviously report the behavior to the authorities. That's not illegal. And here are some of the claims. The parents alleged that the district did not provide a continuum of placements. They should have classified the student as a student with a serious emotional disturbance, also known as EBD. Failed to refer, evaluate, and identify the student in an appropriate, timely manner. Failed to provide an appropriate placement for many years, and violated the stay put provision. Failed to provide the student with extended year services and occupational therapy, and impermissibly reported the student's 2 violent attacks on district personnel and to the juvenile authorities. The parents sought reimbursement for the cost of various hospitalizations and compensatory education. The district requested an order requiring the student and the parent to submit to family and individual counseling with the counselor chosen by the district. Not making these up, these are actually true cases that are out there and reported. So, the hearing officer concluded that the school did have a right to report these incidents and did not have any control over whether charges were filed. The reporting of these incidents did not create a change of placement, and the district was advised that it should have informed the juvenile authorities That it was a student with a disability, and the incidents were related to the student's disability. The district erred when it failed to change the student's classification from other health impaired to seriously emotionally disturbed, which is now known as emotional behavioral disability, AKA EBD, after receiving information indicating EBD was the appropriate classification. So they were on notice of the multiple hospitalizations of this student. The district's own consultant had recommended that the student be classified as EBD, and as a result of this error, the district failed to conduct a complete evaluation of the student and consider alternative placements, not the alternative center when I say alternative placements. And the district had knowledge of the student's problems in the beginning of his first grade year. So as a first grader, they were already on notice that this kid had some serious emotional behavioral disability issues, and yet did nothing until the student was hospitalized near the end of this year. So the district did not have the required continuum of placements, and that's often a problem, especially in your small rural counties. They have kind of a one-size, well, you either go to gen ed or you go to the alternative school. And under IDEA, there's supposed to be a continuum of services. It doesn't mean every service has to be offered in every school, but it does mean that there needs to be more than column A and column B, because we're not at a Chinese restaurant picking out from our menu. It needs to fit the child's unique needs, and oftentimes the challenge is if there's not a program that's already in place, they may have to make that program, because services are based on the student's needs and not on district funding, not on what we currently have available, and definitely not on, that's not how we do it in this county. So, the district had failed to examine whether the student required extended school year. Extended school year is what some people refer to as summer school, but it's not. Extended school year is actually in order to provide a free and appropriate public education. So some students don't receive FAPE in their 180 school days. They need education beyond that. So oftentimes school districts will do some instruction during the summer, but it's not limited to summer. It could be after school, it could be before school, but the usual model is sometime during the summer for X amount of weeks. Well, we also can't determine X amount of weeks for every kid, because it has to be based on your students' unique needs. So some kids may benefit from 4, others may need 8. So we can't just say our ESY program is for 4 weeks, 4 days, 3 hours. That would not meet every student's unique needs. And in this case, there was obviously a contention about needing extended school year. They did not address the student's occupational therapy needs. The student was very tactile defensive, and had obviously social skills deficits. And the district was advised that it could arrange for counseling by a counselor chosen by the parents, not by the district, with periodic consultations as appropriate.
I don't know any school district that has summer school that just continues on. Like in Orange County, it's X number of weeks. So what you're saying is that if I wanted to say, if I could prove that my child needed, so my child does need more than the 5 weeks and he needs the 8 or 9 weeks, they would have to pay?
Yes. And we filed multiple state complaints on districts, because a couple of years ago I had a very ambitious intern who did research on every district's extended school year program. And oftentimes what our intern found was that this is what we offer for extended school year. 4 weeks, 3 hours.
Right.
We start at this date, we end at that date, or your child can get a home packet.
So right now, I am doing that. I am looking for a summer program for an ASD kiddo who definitely needs more than the 4 or 5 weeks that are offered in Orange County?
So I would go to Orange County and say, my kiddo needs more than this 4 weeks in order to be provided a free and appropriate public education. What are you offering? And if they come back and say, we only do 4 weeks for 3 hours, 4 days, that's a violation. And then I would, being me, I would reach out to their school board attorney and say, you know, this is the information. I know that that's not how ESY is determined. So there's a lot of ESY information on the Bureau of Exceptional Education Student Services website under DOE. And we've, like I said, filed multiple state complaints around on different counties for that very reason. So if you have difficulty navigating that system, please call our 800 number and we can assign somebody to assist you in that advocacy. So, the behavior intervention plan was determined to be inappropriate, surprise and wonderment, and the district needed to conduct appropriate behavior assessments and provide an appropriate behavior intervention plan. There was no violation of stay put, and stay put is that whole change of placement. If I don't agree where you want to put my child, I can invoke stay put. Arrests are obviously exempt from the stay put. And the school district was ordered to pay for some of the hospitalizations due to the denial of a free and appropriate public education. So, students' IEP needs to be followed, and oftentimes kids will be arrested from school. The arresting officer will not know that it's a student with a disability. Not that students with disabilities can't be arrested, they can, but they can't be arrested in discriminatory manners. And the agency reporting the crime committed by the child must ensure copies of the special education disciplinary records of the child are transmitted for consideration by the appropriate authorities. So we had this horrible case, this 5-year-old child who had autism, and the student had some very non-compliant behaviors. The school was well aware of it. They had not done an appropriate FBA or a BIP, and the student acted out in the classroom, and the principal called the police, the SRO, and the SRO came into the classroom, handcuffed our little 5-year-old client, slapped him in the back of a squad car, and drove the kid off to the assessment center. The problem with that was the parent was on their way. They were coming to get their child, even though technically under the law, they don't have to come pick the kid up unless they're suspended. But the parent didn't want the student to be arrested, so the parent was coming to intervene. And when the parent arrived, they got to see their 5-year-old child in the back of a squad car. So they called us frantic. We told the parent to call the assessment center, because at least the school was kind enough to let her know where the child was being taken. And so she called the facility, let the facility know that the child was a student with autism, was very limited verbal, did not like to be touched, would get very defensive, and upon processing the student, they released the student back to the parent. And an attorney was, a criminal attorney was retained by the family, and the charges were eventually dropped. But think of the trauma of this 5-year-old child, who, by the way, was just non-compliant behavior. There was a lot of non-compliant behaviors, but there was not an appropriate FBA, not an appropriate BIP, and the principal had put in writing that if this child didn't receive medication, they could not come back to school. Which, like, you could have seen that my eyes, like, probably got about this big, because under the law, you cannot deny a student education and demand medication. I mean, it's actually one of the few things that is actually written in the law, that you can't, say that education is contingent on medication. And we get a lot of that. We get a lot, believe it or not, of I don't think the parent's compliant with the kid's meds. I don't think, I got to tell you, I've had a lot of clients that are over-medicated too. So, they quickly are quick to, for whatever reason, and then when the school catches wind that mom took them off because they were having some side effects, and mom hasn't gotten the approval of the doctor, and, it gets kind of ugly, and then we get into this whole medical neglect issue and non-compliant behavior. So anyway, long story short, the child was returned to school, an FBA was conducted, an appropriate BIP was developed, and an IEP that addressed the student's behaviors. So, but again, I can tell you quite often when we contact the arresting officer, even the school resource officers, the usual response back to us is, "Oh, I didn't know the kid had a disability. So they didn't tell me that. I just came in, I saw the kid, tearing up whatever, and I'm a law enforcement officer, and that's a crime." And so I have a big issue with school resource officers being utilized as behavior techs in classrooms. And we actually have a district in our state that flat out put in writing that it is their right to use their SROs as they see fit, and they use them for behavior intervention, and they will continue to do that. So, needless to say, we have to file. Yeah. So the school may transmit the copies, obviously in accordance with the Family Educational Rights and Privacy Act, and I don't really think as a parent you would object to having your student's IEP follow, because if you want that educational services to follow the student, and oftentimes there's a disconnect. So I end up going into the facility and my client's IEP is not being implemented. So these are just some of the stats that I thought were pretty egregious. 4,985 students with disabilities in Florida received referrals to law enforcement back in 2011, 2012. 44 of those students were served under 504, and 4,941 were served under IDEA. And then I went to the trauma-informed training yesterday afternoon, which I thought was very good, and they had some more information on 2013, 2014, which I was not finding, and they said that during that school year there were 10,340 school-related arrests in Florida public schools, mostly for minor infractions. So on my soapbox, I'm going to again say that school resource officers should not be used as behavior support in school. And I am of the mindset that I think pretty much every district has school resource officers, but yet there's a shortage of counselors. So I would rather have officers in the streets, back in the communities where they belong, and therapists in the school. And if I ruled the world, that's what would happen. But unfortunately, I don't. So, but that would be what I think would be. So, unfortunately, the U.S. incarcerates juveniles unequally, and as a result, improvements have bypassed some of our children. So we found that there's prevalent studies have found that 65 to 70% of the youth in the justice system meet the criteria of a disability. And at least 75% of the youth in the juvenile justice system have experienced traumatic victimization, leaving them at risk for mental health disorders and post-traumatic stress syndrome. So Baker Act is our last topic, and this is our last scenario. And so Sam is 8 years old and has been diagnosed as having autism and is nonverbal. The student is in a self-contained classroom and does not have a behavior intervention plan, as the school has a school-based plan, often called level systems, which sounds eerily familiar to the juvenile justice has level systems. But anyway, Sam is constantly acting out when it's math center time, as math is a non-preferred activity. The aide in the classroom is attempting to instruct Sam, but he refuses to complete his work. The aide takes away Sam's fidget because he refuses to complete the math classwork. Sam becomes aggressive and knocks the books off the desk and starts to throw items in the classroom. Anyone want to take a stab at this one? Right over there. Oh, and there's a little more information, young lady in the back. So the aide and the other classroom assistant placed Sam in a restraint, and he continued to attempt to hit and kick the aides. They stop the restraint after he calms down. He starts a tantrum when the aide refuses to return the fidget, which he utilizes when he becomes overstimulated. The teacher calls the resource officer into the classroom, and the student is placed in handcuffs and taken in for involuntary commitment.
Well, for one thing, it's not individualized at all. It doesn't take into account his particular disability and his particular needs. And taking away something that he uses to calm him down is, of course, going to aggravate him. And then it's not positive. All the interventions they're doing, they're all negative.
Yep, absolutely. And I see one more hand up here.
There's also no functional behavior assessment, so the plan's not individualized, but you couldn't make a individualized plan that has a professional basis because you never did the observations and identified the function of the behaviors.
Yes, correct. So, good answers. And the school should have conducted a functional behavior assessment and drafted a positive behavior intervention plan. Sam is nonverbal and behavior is a form of communication. The teacher should have been providing the math instruction. How many times do the aides instruct students? Aides are not there for instructional purposes. They are not certified teachers. So the aide used negative consequences rather than positive behavior intervention strategies when taking away the fidget, which Sam used for sensory issues. The staff should have utilized de-escalation techniques. They conducted a restraint and did not file a report with the Florida Department of Education, nor did they provide the parent with the required notice. So they need to notify the parent that day, and within 3 days, file a report with the Department of Education. And they did not do any of that. The school should have utilized trained behavior staff to attempt to de-escalate the student and not a school resource officer. As for the Baker Act, which I am not a Baker Act expert, but I can tell you, the officer was not advised he was dealing with a student with autism. The student does not have a diagnosed mental health consistent with the definition in the law, and the student had calmed down, but the aide's refusal to return his fidget elevated the situation. And so Baker Act is often misused in this context. There was no reasonable belief that the student had a mental illness, and just being a danger to self and others would not be sufficient unless it resulted from a mental illness. And the criminalization of developmental disorders or mental health diagnoses should always be avoided. And we have a lot of problems with Baker Act being used in schools, and unfortunately, it's one of those, what is the lesser of evils? Because if they don't Baker Act, they arrest, and neither are a good option. And I do see an overuse of both. So you know this is a student with a disability. There should be an FBA, there should be a BIP, there should be trained behavior staff. Kids are getting Baker Acted for tantrums. I've been told enough times that if I had a dime, I'd probably retire now, that we don't Baker Act unless the student meets criteria. And the officers are trained and they know to do the assessment, and if the student meets criteria, they will be taken. But oftentimes we find out that magically by the time they got to the center, they're immediately discharged because they don't meet criteria. So it's a problem, it's a big issue, and we really need to be very proactive about making sure that functional behavior assessments are done and behavior intervention plans, positive behavior intervention plans are being implemented, and that we're not overusing Baker Act. I'm not saying that there's not a time and a place when somebody might meet the involuntary examination criteria, but oftentimes it's just overused, and it could have been done. It's also the same problem with restraint and seclusion. It's an overused, it's a crisis intervention. It's not a behavior intervention plan. And it's not to say that some students don't sometimes have comorbid. They may have a developmental disability and a mental health issue that was not diagnosed or diagnosed but didn't meet eligibility criteria, so they don't put it on the plan. But unfortunately, I've had clients who've been on a medication regimen, and then they get put in a Baker Act facility, and then that doctor changes their medication, which concerns me because certain meds have to be weaned off, and yet we're just stopping them and we're putting. So there's a whole lot of issues there, and a whole lot of concerns that I have with the use of Baker Act in schools. Yes.
I think that's important because I think one case, it wasn't my case, but I happened to be working late in my office, and I'm a CLS attorney, and the child who I found out was autistic, he was, from earlier in the day, he was instructed, the school contacted the caseworker and said he was out of control and that he's in a specialized class, but whatever the reason, he was having very violent outbursts. We had to pick him up. The caseworker picked him up. It was a difficulty because she had to pull over several times, but she did get him back to the office. But then what happened then is what is perplexing. What role do the department have to play in dealing with these situations, which it seemed like no one really knew what to do. He is an autistic child. I mean, I actually saw the behaviors where, because how I got right down my hall, they was monitoring him going to the bathroom, and he actually took the top off the commode and smashed it to the ground. And then they got him calmed down for a minute, and then he actually, he looked calm, but then he just smacked the caseworker in the face. They called law enforcement. Law enforcement was actually able to really, it was amazing how that officer was able to interact with him, but they wanted the law enforcement to take him in for a Baker Act, which he did. He was able to, communicate and get the child in his vehicle, but again, just like you said, he was released because he didn't meet the criteria for a Baker Act. And basically, he was brought back to our office, and he had the placement. His grandmother did not want him back home, and the child, they had him literally. The caseworker went home, got her pajamas, and slept in the office with the child. But it's like we don't have any clear way of dealing with that other than, and I see this routinely, trying to send, when we don't have any other immediate placement, is to send them to the hospital for Baker Act, and they won't keep them. So I don't know what responsibility we should have, or what we should have done in place of that. I mean, legally, he had attorney ad litem. I mean, they came to some resolution as far as placement, but really, I mean, legally, I said, you had that child sitting in the office sleeping for the night, which he did tear up our office. Mm-hmm. It's like nothing else we could do. But you want to help them, you want to make the right choices. But it seems like sometimes we just, as in government world, we just don't have the proper resources to react when these things happen.
And it's unfortunate because if the student had an appropriate educational setting with appropriate supports and services, with an appropriate behavior intervention plan, that child should have never gotten to that point where they were escalated to the point where they were not in the rational state to be able to be de-escalated. And I'm not saying that, sometimes you can do everything by the book and still have these outbursts, but what we're finding is the people are not trained. And so since there's no requirement that there be a BCBA or a CBA involved, we have people who are writing plans that are not qualified to write plans. And they're punitive as opposed to positive. And they're their de-escalation techniques are not something that works with their child. And the one thing about IEPs and BIPs is they're living, breathing documents. If they're not working, go back to the drawing table and tweak them. And some of my clients, there have to be weekly meetings and fidelity checks, and they have to look at the data, because if it's not working, you've got to readdress it. Obviously, if it's not broken, don't fix it, but if in that case where that child has gotten to that, there's a reason why that behavior got to that point. It didn't happen, I get a lot of, he chooses, he's just willfully and wantfully disruptive, but behavior has a function, and oftentimes there's some communication, something we're missing. And so if we had the positive behavior services in there, you all should never had to pick the child up, and the student should have never been Baker acted.
And then the next day, they took him back to the school, and, because that's what they say, well, okay, we're going to figure out his placement while he's at school. But no, they said, we're not taking him back.
And they have to take him back.
And they didn't. And so that was the whole thing. I don't
Yeah.
know what the outcome is. Later on, he ended up going into, a home, a special home. I think he ended up getting into an APD home. But during that time, I remember them going to the school, and then I said, didn't you just leave to take him to the school? Because I was back there at like 7 o'clock, 8 o'clock in the morning. And by 10 o'clock, the caseworker was back with him, sitting in the office, saying the school would not take him.
Yeah, see, and the school has to take him back, and if they need to do an emergency IEP and the legal guardian needs to waive the 10 days to do this, they need to get back into the planning mode of what they need to do to provide that student with appropriate services, because legally they're obligated to provide a free and appropriate public education. And oftentimes, like I've been told with suspensions or expulsions and things, well, we needed a cooling off period. But you may be reinforcing that behavior, because if my function is task avoidance and you send me home, I know now I'm going to do that again because I get to go home again. So oftentimes, I have to tell you, we focus in the education world on data-driven, research-based, yet there's no research to support suspensions and expulsions or a deterrent to the behavior. And then I'll get told, well, teacher needed a break. And no disrespect, I get it. Teachers work very hard. They're underpaid, underappreciated. And I'm not vilifying teachers or law enforcement officers, but that's not the role that they're supposed to be playing. Teachers are supposed to be teaching. Resource officers are supposed to be, out there looking for crimes that are not manifestations of the child's disability. So it was the school's responsibility to get in there and get all the agencies involved to the table to decide, because I have to tell you, I have represented some extremely behaviorally challenged kids that there was no magic wand, and it took a lot of planning and a lot of meetings to figure out what that child in crisis needed. But there is a function to that behavior, and if we don't address it and we just keep throwing the kids away and moving them on to be somebody else's problem, we're going to have a lot of dysfunctional adults in our society. So we need to teach these children appropriate behaviors. And the other thing too about that I just wanted to notice, it's an interesting component that they talk about in the involuntary examination statute about whether the apparent harm, such harm may be avoided through the help of willing family members, friends, or a provision of other services. So that's something that's often missed. So what other services, what interventions, working as a community, the student has behavioral services in the home or in the group home, getting everybody to the table to make sure that there's an appropriate plan in place for that student. But it's not okay for schools to just send kids home. And it's and oftentimes I get told, well, we just don't know what to do with them. There are a lot of resources and discretionary projects through the Bureau of Exceptional Education Student Services, known as BEES, which is housed at the Florida Department of Education, that can help provide these schools resources and services for free. So oftentimes they don't even know that those things are available. But the one thing that is not acceptable is just throwing our kids out the door. They're entitled to a free and appropriate public education. So, any other questions or, yes? Oh, and if you wouldn't mind, if you could pass up your cards, we'll do the drawing for the.
I have a question regarding, if you come into a case as an attorney ad litem and the child's already in an alternative school and you're told they can't go to public school and they want to go to public school and they're told, no, he's been here, and they have situations at the alternative school as well, but what would you do as an attorney ad litem to try to advocate for a change back to public school?
Well, the first thing I would want to know is what put the student in the alternative setting and if that was done appropriately. And then where can that child's IEP best be implemented in the educational plan? Because oftentimes I will tell you the alternative schools don't have the special ed services and resources available, so that child's not receiving a free and appropriate public education. So I would want an IEP immediately to look at the educational services and supports that student needs and to determine the best placement, because ultimately a student doesn't have to stay at a alternative setting because for X amount of days, the IEP team needs to determine where that student receives FAPE.
Just real quick, so your agency is available free for
Yes.
consultation? Any, like as a guardian ad litem, I could call and give you a hypothetical and you could tell me, yeah, do this, do that, kind of like what we're doing here today?
Yes, and just know, like I say, the advice I give is only as good as the facts I'm given, so I'm like Monday morning quarterbacking on, what, but yes, we're free, legal, confidential services. We are the state's P&A. That's our role, to ensure the rights of people with disabilities. So absolutely contact us. We have our intake information. You'll go through the intake process, and I can say that all educational cases, questions get moved over to me for review. Obviously, if they're stuff that we handle. I mean, we handle only situations for people with disabilities. So if you're calling me about a FSA question, I'm not the person. But if you're the new FCAT, those kind of questions, not my area. But if you're calling about especially behavioral students who are being denied free and appropriate public education, definitely falls within our goals and priorities. We have some information on our website under our disability topics, which is in the process of being updated. But yes, we do consult. So, any other questions? Oh, yes.
I'm a little confused about something you said earlier. You said that only the IEP team can change placement, but at a manifestation determination, if it's determined that it's not a manifestation of the disability, can't the result of that be a change in placement regardless of whether the IEP team thinks it's appropriate?
No, well, yes and no. Yes, if it's not a manifestation of the child's disability, the student can be disciplined in the same manner as their non-disabled peer, but FAPE must be provided and the IEP team gets to determine placement.
Okay.
So I violate the code of conduct. Let's use something that's clearly not a manifestation.
I'm asking because I did a manifestation and it was a child who brought like a water gun or something to school. And it was determined that it was not a manifestation of his IEP because his IEP was EBD and this was a manifestation of ADHD, which I'm just not going to get into, but it was determined that it was
That's an improper determination because it's not based on the label, it's based on the manifestation. And by the way, was he in trouble because bringing toys to school?
It was because it was a weapon.
A water gun does not meet the definition of a weapon.
Maybe it was something else. It was a weapon. I mean, it was a weapon.
Okay, so then you're under your extraordinary circumstances, and an IEP team still has to determine the placement.
Okay.
Yeah, so if I truly bring, and there's a definition too, as far as knives go. I know this sounds like I'm splitting hairs, but there's a definition, because we actually had a kid who brought one of those little Swiss Army keychain knives.
There has to be so
And
many
there has to be a
inches.
certain amount of inches for it to actually be considered a knife. So familiarize yourself with the statutes, and oftentimes we've had actually these things overturned because the student needed services and they weren't getting the appropriate services. And that's part of it, was the IEP in place implemented, but was it even appropriate? Because oftentimes they're not.
Yeah, I mean, in this case, it was determined that it was not a manifestation of his disability, and so he had to go to the, it was a center school, not an alternative school, because the alternative school was not appropriate, but he couldn't stay at the mainstream school. And everyone in the room agreed it was better for this child to stay at the regular school, but because of the disciplinary code, he had to be moved to this other school.
Nope. Doesn't have to be, because the IEP team has to determine where that child gets FAPE.
Okay.